Hi, I'm Ken Vercammen, and I'm here to talk to everyone about wills, probate, estate planning, and I'm a local guy. I live not far from Riva and not far from Farrington Lake, so I know a lot of people in the North Brunswick area, and I'm glad to help people out. So, number one, though, I always say a lot of times people says, "What Kenny, why do I need to have a will? I'm married. Doesn't everything go to my spouse?" He goes, well, yes and no. Depends upon whether or not someone it's a first marriage or not. But number two, let's see, that's not doing planning. That's just hoping that the other spouse lives forever. So by doing planning, you're really helping your family by saving them money, cutting down on aggravation, and because number one, let's say some people don't have a spouse, so if there is no will, then state law determines who gets assets. Let's say there's three kids and they all agree. They all agree upon who's going to be the administrator, because when there's no will, it's called the administrator. Well, interestingly, it still becomes a project, because that means that all the children have to sign what's called a renunciation, saying, I don't want to be the administrator, and I'm good with X person serving as the administrator. It's supposed to be signed in front of a notary. Then you're supposed to file it with the court and surrogate court and pay a fee. And that's where everyone agrees. Sometimes you get one of the people that doesn't agree or doesn't respond. Then the court may say, listen, you got to file a complaint order show cause, and it has to go in front of a superior court judge, and the superior court judge is going to determine who's going to be the administrator. Now, our superior court judges are great people. They're very helpful. However, to get in front of a judge, you're looking at spending, $3,000 or more in court costs and fees just to get in front of a judge. Certainly, doing a will only costs maybe $400, $500, and you can get it done right. So, just saying, well, I'm not going to die ever, or I don't need that, is not good planning, and you're not doing your family a favor, because by you not doing the things now, it usually causes them to have to spend more money down the road. Also, if there is no will, or if someone did a will and it doesn't have some magic words, there's a thing called the surety bond. So most wills prepared by an attorney have a clause that says no bond required. This way, the person who's the executor when there's a will doesn't have to take out this insurance policy and pay $1,000 or $2,000. If there's no will, though, the surety bond is required. Three, if there's no will, state law determines who gets your assets, not you. And more people are not leaving money directly to their kids. Sometimes they're leaving it to grandkids. Sometimes they're saying, listen, I'm not going to give it equally because one of the kids, telephones me and calls me all the time, and the other one we never, isn't helpful. If people have minor children, and no one who's young thinks that they're going to suddenly die, but if both parents happen to die, that means a total stranger determines who gets custody of children. That's the superior court judge. So most people with young children have a will that can say, listen, I want guardian number one to be this person, guardian number two to be that person. Plus, by not having a will, you kind of lose the opportunity to do planning and to try to make things easier for your family. So you got to think, let's see, when loved ones are grieving and dealing with death, you want to give them more problems and possible lawsuits, because that's what we see all the time when people don't do any planning. So someone's overwhelmed with the after the funeral, there shouldn't be more things. So having a will done oftentimes alleviates what the problems are. So you got to kind of think first off, okay, who do you want to get your assets? Who don't you want to get your assets? When there's minor children, who would not be the best person to raise the children? Who would not be a good person to be the executor? Remember, when there's young kids, let's say there's... And then you can pin him so he'll become big. Let's say there is no... person in the family. Some people will select someone to be the executor who's outside of the area. So, Now, also, the county surrogate also reminds people, beware of some of these online forms not prepared by an attorney, because the problem when they do these online forms is that, oftentimes people don't sign them correctly. They don't fill them out correctly. So, nowadays, I wouldn't want to do my own electrical work. I wouldn't want to do my own plumbing work. Yeah, when I bought my first house, I started trying to do stuff myself. So it's best to have a professional do it right, and having a self-proving will. So, one of the things, though, that, when COVID hit, the state closed down for the end of March, beginning of April. But, in a way, we learned how to make it easier and more convenient for people. Because, in the old method, we would mail out in the mail or fax someone a questionnaire, and they would take a pen and fill it out. Then they would make an appointment, take a day off of work, or half a day off of work, and then come in. And some of the people didn't fill it out, so you're in a reception area of a law office. Nowadays, to assist potential clients and everyone, most attorneys offer document preparation remotely and consults remotely. When during COVID we would say, we're concerned about your health and well-being, and now we have the magic words, we're concerned about your convenience. Because even when I go to doctor's offices, I say, listen, can you send me the form ahead of time so I can fill it out ahead of time and then send it to you, so I'm not trying to scribble stuff when I'm in your office. So the attorney emails you a short questionnaire. You type up basically who's executor 1, who's executor 2, who's getting your things. If there's minor children, who would be the guardians. And then after that, the attorney calls up. Then people are able to pay by credit card online, directly. Some people are old-fashioned. They goes, listen, I want to mail a check, and okay, that's fine also. The attorney prepares the documents. They email out the documents. The will, power of attorney, living will, sometimes the trust. And then people can read them at their leisure. Although I do recommend that it's better if people print out the documents, because we know that we read more thoroughly if we are actually looking at a piece of paper than trying to just read something on our iPhone. Because when we're looking at our iPhone, we're not going as carefully. And then, nowadays, people have the choice of, either signing in the law office during business hours when there's witnesses present, or signing on the weekends at their own notary, signing at work at a notary with friends that are can be witnesses, or going to the UPS store. So, let's see. So, logistically, what do you get? What does the will questionnaire have? Believe it or not, the will questionnaire has been shortened, because the attorneys used to ask many, many questions dealing with your assets, but now New Jersey did away with the estate tax. It used to be every cent over $675,000 that wasn't going to a spouse was taxed, and that required, a substantial amount of estate tax planning. So we need to know all the assets. Now, we don't really need to know as much. So, you're going to type in now, who's executor 1, who's executor 2. Okay, some of the people, listen, not everyone is super computer savvy, and people have said that to me. He goes, listen, you can have your child or a friend or a family member help you out. They can type it on their computer and then email it in. But that way, we at least have it in a typed form. And the great thing that would, my cell phone now can read when it's typed up text. So when I'm driving, instead of listening to the Rolling Stones, sometimes I can listen to what someone had typed in an email or in a text. But we can't read something that's handwritten or a PDF. So anyway, you're going to put in who's executor 1, who's executor 2. You never want to have co-executors. The worst thing. It creates problems all the time. Because it means that two people have to do everything. Two people have to sign the paperwork for the surrogate. Two people have to meet with the realtor to sign the listing. Two people have to sign the contract. Two people have to sign the addendum. Two people have to sign every single check. there's a reason why there's one captain of the ship, not two captains at the same time. And I told people, it goes, listen, you could have twins living together, but you still want to have a number one and a number two. So, people sometimes, I don't want to hurt their feelings. Okay, listen, we're just going to flip a coin. And that's for people who get along. Sometimes we've had, I was in court with a case where there was two brothers and they couldn't agree upon what color the sky was. Brother number one would say the sky's blue. The other one says, no, the sky's gray. You're stupid. You've always been stupid. And always remember the judge saying, fellas, why don't you go outside and have a cup of coffee? Think about, you had good times when you were younger. Think about all the good times you had. Now, you still want to provide your attorney in writing with a list of what your assets are, New Jersey and anywhere else. Because if you have assets in another state, then there's a process called Ancillary Probate. And now New Jersey probate is very easy, and I'm going to touch upon the probate in New Jersey later on in the program. So logistically, let's see, you're typing in what real estate you have. And then we tell people, listen, ballpark, what are all of your other assets? Let's see. Now we do remind people, to remind them that certain assets passed by title, not by will, and a will can't change that. So I'll give you a couple quick examples. If a house is owned husband and wife, one of them passes away, the house automatically goes to the survivor. The will can't change that. If you have bank accounts, payable upon death, joint tenancy, automatically goes to the survivor. The will can't change that. So if your will says, listen, any bank accounts I have at Bank of America go to this particular person, but there's a different beneficiary listed with Bank of America, it's whatever you have by your, by that title with the bank, not what your will says. If you see these beneficiaries, again, it goes to wherever you put as your beneficiary. Certain assets pass by contract. So examples of those are IRA, 401k, life insurance, annuity. Anything that has a direct beneficiary, the will cannot change that. So I recommend to people, listen, never assume, always be 100% sure. You get a printout, and that way you can put it in your folder that has your will and other documents. I was married for 15 years. I, made my wife the beneficiary of everything, and, married 15 years. I don't know, one of my life insurance policies still had my dad. Now, of course, I knew my dad would do the right thing because, he always does the right thing, but, never, you don't want to create more work. Then you're going to list who your beneficiaries are. And you got to think, okay, if that beneficiary passes, who would get their share? Let's see. Now, also, some people have what's called, let me go back. Now, you want to list who your assets are. And it's, aside from disowning a spouse, it's your right to leave your assets to the people that care about you and are there for you when you're in your need and care about you. So a client 2 years ago said, do I have to treat all my children equally? He goes, no, it's whatever you want. What's your concern? He goes, well, one of my kids lives on the West Coast. We don't hear much from him. I go, well, let me ask you a question. Did you even get a card or a call on Mother's Day, Christmas, or your birthday? The lady goes, no. He goes, why are you leaving that person anything? You just have a clause that says nothing to X. Last year, a fellow I know for a lot of years says, listen, I want to change, my will, because I don't hear from my daughter, I don't hear from my grandkids. I want to change it around. So again, it's your right to do with your assets what you want. But again, we talk about a call to action in getting things done rather than being a putter offer. Because what was happening was people go, oh, it's a winter time, it might snow, but then once the summer comes around, people put things off because it's nice out, they don't want to do anything. Get it done. We've never had anyone after doing a document say, oh, I wish I didn't do that. They're glad they got it done. So some people have what's called specific bequests. A specific bequest is where assets are going to a specific person. So some ladies say, I want my jewelry to go to my granddaughter, my daughter. Some of the men say, I got my hunting rifle and hunting stuff goes to a nephew or a person who's a sportsman and also has a firearms license. Some people have what they consider to be valuable to them. Okay, that makes them feel good. The reverse specific bequest is nothing to and name a person. You don't leave them a dollar. We don't put a reason. Also, we want to have a clause that says no money goes to young people. We're not trying to stiff them, but we don't want 19-year-olds inheriting money because 19-year-olds don't do smart things with money. I mean, just think, if I would have inherited money when I was 19, I would have bought a red fast car and went to Seaside with my buddies from the track team and spent it all. So we sometimes have a clause that says, listen, these minors don't get the money outright. They get some when they're 22, some when they're 25, the balance when they're 30. However, the trustee of the money can expend as much money as is needed for health, education, maintenance, support, college. And boy, you have no idea how much college costs now. When my son went to University of Miami, 10 years ago, he had a choice between going to Miami, which was $45,000 a year, and Vanderbilt, which was $55,000 a year. Now I think the cost is close to $100,000. So more and more people are saying, listen, rather than giving it to my kids, I already have a house, I'm going to leave it to for their college. So think of the trustee is the one that holds the money, the guardian is the one who holds the kids. Some people, some of the people that minor kids, I can't really decide. He goes, listen, let me help you out. If you couldn't come home for the next 2 weeks, who would you trust watching your kids, and who would you not want? And there's no best person to raise your own kids. Now, one of the things a surrogate has issues with is people trying to do these cheapy things online, and they're not done right, and it becomes a problem for you because the only thing the surrogate can say is we can't admit this to probate. Now there was a new law a couple of years ago called the self-proving will. Prior to that, the person signed, 2 witnesses signed, but then one of those 2 witnesses had to sign documentation with an affidavit. They would saying that they were the witness there. Well, sometimes you couldn't find the witnesses. One witness in a case said, yeah, I'll sign the papers. I want my fee's $500. Executive goes, we're not paying you $500. Then the witness goes, okay, good, get the other witness. Well, that person's dead. Yeah, my fee's $500. Otherwise, you got to go and file a complaint in the Superior Court. So the self-proving will statute was started so that we don't have to locate the witnesses. The good thing is that we are, that's a person signs, the 2 witnesses sign, and the attorney and notary signs. And then we do it again with certain language that way we don't have to find the witnesses down the road. But I know these these cheapy things online, does not have the magic amounts. Our questionnaire, though, does ask, is anyone receiving SSI or SDD, or is there any reason why someone should not receive money? If someone's getting government benefits, you don't want them to receive money outright because they may lose their eligibility. If someone has a substance abuse problem, alcohol problem, drug problem, gambling problem, you don't want to leave money outright. So some people set up a trust within the will, similar to the trust for the minors, a trust for that person where the money's held for their support and can be used to pay their rent, pay their car insurance, pay for food for them. Because if you give an alcoholic, $50,000, they'll buy $1,000 worth of booze and then blow the other money. So the whole idea is doing things to protect everyone. Okay, so you know, you contact the attorney, you fill out their form, you pay the attorney prepares the documents. If they're good to go, I mentioned that you know, most people just want to sign in front of a notary and their own witnesses. A spouse can be a witness on the will. Other people like say, listen, I want to come in your office on Tuesday at 3 o'clock. Okay, listen, you know, we try to work with people. Some people set up a special needs trust for children that have special needs. You know, cost for wills, you know, when it's basic wills, usually cost between $400 $500. That's a lot less expensive than having to go through an administration. The interesting thing though is some people are put off. Oh, I want to read more about it. And I go, you know, you don't need to read about anything. That's why you're hiring the professional. Let's say, you know, when I had knee surgery, I didn't read anything about knee surgery. I knew the doctor was one of the best. He was recommended by the Rutgers track coach, and you know, I didn't need to ask him 101 questions. So I've told people, it goes, listen, you don't need to read about, you know, how to prepare a will, etc., because that's why you hired me. You know, I went to law school, I passed the bar. You know, I attend seminars, I wrote a book, I give seminars, so I keep up on this. You know, if someone asks me questions nowadays, tell me about workers' comp law, I go, I don't know. This is what I'm doing for a living now. So you don't need to read stuff. Oh, and by the way, more and more people now have what's called, legal insurance, where they have a plan through their company. Through some of the major ones are MetLife, Hyatt, ARAG, Legalese, where you know it covers preparation of the will. Okay, after some people though will. My mother-in-law used to ask me every other year, I want to come in and get a trust done, and I would say, "Were you watching Susie Orman?" She'd say, "Oh yes." I go, Susie Orman is right if you live in New York, California, Florida, where probate is very, very complicated. However, New Jersey, probate is easy. So I ask people, why do you want to spend $3,000, $4,000, $5,000, $6,000 on doing trusts when a $400 will, $500 will help you out? Let's see. There, in other states, though, if you have property in Florida, California, New York, you want to have a trust and have that property owned by the trust. But for the purpose of New Jersey, probate is easy and inexpensive. A trust usually costs $3,000 a piece. Secondly, you're not owning the property anymore; it's owned by the trust. A revocable trust does not protect assets from nursing home or Medicaid. And some of the trust salesmen tout, a trust is private, and a will is a public record. Yeah, but unless someone's leaving their money to the Ku Klux Klan, what do you care if the world knows that your property is going to your kids? And if it's going to be if the property is going to be put into the trust, number one, you got to get permission from the mortgage company. But also, there's you need a new deed, affidavit of title, seller's residency form, a couple other things. Some people, though, do set up what's called an irrevocable trust, and that's the kind of trust that people want to shield their assets from Medicaid. However, it has to be irrevocable. You're not owning it anymore. You can't be the primary trustee, and you got to hope that at least 5 years go by, because it's a 5-year look-back period. Now, logistically, after the will is signed, we recommend that people do a couple things. Number one, they should advise in writing Executive 1, Executive 2, where the original is at. Don't put in a safe deposit box, because people can't get into the safe deposit box. 2, you want to take the power of attorney and scan it and, send it to Agent 1, Agent 2, send it to your financial advisor, your life insurance person, your accountant. That way they know that, something happens to you, you have someone who you trust that can deal with those people financially. and also it's a good idea to scan the living will. You email it to yourself, agent 1, agent 2, and your doctors, because there's a law that says the hospitals has to ask if you have a living will prior to having any surgical procedure. And by the way, I always tell people attorneys typically charge consult fees. My office charges consult fees, but if someone is nice enough to attend one of our seminars or listen to one of our webinars, then we don't charge the $200 consult fee. We do the consult. By the way, a will is good forever. It never expires. Now, that doesn't make you not want to do changes to your will if it is recommended, but a will doesn't expire in 5 years, 7 years, whatever. And there's no statute that says the power of attorney expires. However, I always tell people it's a good idea to re-sign or sign a new power of attorney if more than 5 years go by, because some of the banks give people a hard time, or if your agents have changed their names or changed their addresses, because typically the power of attorney says, my agent number 1 is this person residing at this location. Well, if your agent is your daughter and your daughter gets married, has a new name and has a new address, they're going to have a lot of difficulty. So attorneys don't charge a lot of money for doing documents compared to the amount that it would cost if there was, have to be court procedures. So the next document I'm going to talk about is the power of attorney. What the power of attorney is the will takes care of your assets if you pass away. What the power of attorney is you're giving power to a trusted person, typically a spouse, like family member or someone you really trust, to be able to make sure your bills are paid and act on your behalf financially. Let's say, so now, interestingly, some years ago, a lot of the banks were giving people a hard time. They were saying, it wasn't, that power of attorney wasn't done on our form, and you need to fill out the Wells Fargo form, blah, 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 blah. And so the legislature came out with a law that says, listen, if the power of attorney makes reference to the specific New Jersey statute, then the bank has to honor it. However, has to make reference to Section 2 of PL 1991, C 95, C 46:2B-11, and we're pretty sure those cheap things online don't have reference to New Jersey statute. Let's see, we've been revising and updating our documents as the law changes. Recently we added a HIPAA authorization to the power of attorney. We added an ability to make medical decisions under POST, POLST. We also last year revised it to have the person who's your agent also be your designated caregiver pursuant to the New Jersey statute 262H5-26. So I do recommend that the power of attorney be a new one signed every 5 years. A power of attorney is effective either right away or only upon disability. We recommend people make it effective right away. That's effective right away. So there's a term like durable power of attorney. That means it's effective right away and stays effective even if someone becomes disabled. A springing power of attorney only springs into effect if someone becomes disabled. I had a client who I liked, and he goes, Kenny, wait, he goes, listen, I'm a carpenter. I don't understand legal terms, springing and durable. Explain to me in carpenter terms. He goes, okay, Fred, listen. If your will is effective right away, that means your son, who's the agent, can steal all your assets right away. If it's effective only upon disability, your son needs to get a note from a doctor before he steals your money. Knowing that, do you trust your son? He goes, I trust my son with my life. He goes, okay, listen. Make it effective right away, because if it's effective only upon disability, that makes it a problem, because you bring the power of attorney to the bank, you bring a note from the doctor. Some of the banks will say, well, how do we know this is still good? What if the person is better now, etc. The important thing about having a power of attorney is You never know when you're going to get sick or be in an accident or disaster strikes. Once a week, we get a call from some family member. Oh, we need to get power of attorney over mom, dad, or Uncle Joe. I goes, well, okay, when can we talk to Uncle Joe? Well, we can't. He's at the hospital or in a coma. I goes, well, you can't get a power of attorney over someone. They have to affirmatively give it to you. We've done things for people in hospitals where, as long as we can talk to them, then we're good. Then we can prepare the documents, because I can say, hey, tell me what you want. But if we can't talk to them, we can't do the document. And then you're stuck having to spend $4,000 going through a superior court guardianship to declare the person incompetent. So instead of spending $100 on doing a power of attorney, you're having your family spend $4,000 of your own money. So you have not saved anything. You've created more heartache and aggravation for them by not having the power of attorney. So you get the power of attorney. You get the power. No one can predict anything. One of my high school friends, whenever I saw him, he'd say, "Oh, Annie and I got to come in and do the will. We got to come in and do the will." Well, going back, this guy worked at in the World Trade Center for Morgan Stanley. So the day after 9/11, my office gets a call, and it's the guy leaves a message. So he goes, I think I should get the will done. And I call him up, and he goes, yeah, I'm so glad that you're able to get out of the building. He goes, let's get it done on Thursday. He goes, well, I'm kind of busy. He goes, busy doing what? The terrorists blew up your building. You were able to escape the worst disaster. What more do we have to tell you to get the documents done? So don't put things off. Most attorneys will have up-to-date documents, stuff you find online. You don't know when that was done. The next document you want to have is a living will advance directive. Some of the people remember, heard of the Karen Ann Quinlan case, and then there was a Terry Schiavo case that went to the Supreme Court where the family's fighting over whether or not to remove life support. And remember, the living will is a document. It isn't even for you. It's so that your family does not have to go through the trauma of making the decision. I remember one time, it was a person that they did not have a living will. They had a power of attorney. I was the person on the power of attorney. And the doctor says to me, well, should today be the day? Should we remove life support? Now, you know what the right decision really is for someone who's 92 years old that is not going to, ever get out of the bed, open their eyes again. But you hate to be the person to say, okay, fine, end it today. I couldn't even do it for my dog when my dog was sick. So the whole idea, you're doing it so you don't put your family through the trauma of them having to decide. I used to say, if I can't run every day, I want to be put down like they do the racehorses that break their legs. Well, it's not as extreme now, but, I don't want to be where I can't get out of bed, etc., etc. Let's see. So, we took some language from the Medical Society that's helpful to the doctors. So, Section 8, fluids and nutritions to be provided or withheld. So nowadays, 85% of people say withheld. There's no hope for them. They're not going to open up their eyes again. Section B, artificial, machines and treatment. Most people, 99% of people, initial 1, 2, 3, 4, if there's no hope for them, don't put their family through the agony of, basically, it's a brain dead body that, people are suffering looks there. In a will, the person who's the captain of your ship is the executor. So there's executor 1, executor 2. The power of attorney, agent 1, agent 2. Typically the same person. In a living will, you have agent 1, agent 2. it can be the same person, or it could be a different person, because some people say, listen, I want someone to be the person who's best with the money, but someone on the other hand in the family that will be, knows about, my wishes and knows something about medicine. But again, it's important to have this living will, because without it, there's nobody to decide things. And what we sometimes see is that all of a sudden someone has they're hospitalized and they can't talk for themselves. And then the family member, flies in, barges into the room and says, okay, I'm in charge now. Well, you want to be able to say, no, you're not in charge, because mom or dad did a living will back in 2022 and you're not in charge. Let's say, and we also recommend people sign the organ donor portion. I went to an interesting seminar put on by the NJ Sharing Network, which handles organ donors in the state of New Jersey. And I said, hey, what's the maximum age to be an organ donor? And they go, there is no maximum age. He goes, well, what's good on a 85-year-old guy? And they said skin and cornea. He goes, wow, I never thought about that. If I was burned in a fire, I'd rather have old guy's skin than the stuff that got burned off me. If I can't see, I'd rather have the old guy cornea. I also asked the question, what diseases disqualify people from being an organ donor? And at the time, the only disqualifier was HIV positive. Surprisingly, that was taken away. They'll no longer disqualify someone, because someone who's HIV positive can donate a kidney, whatever, to their partner if that partner is HIV positive. So we recommend people sign the living wills and sign the portion that says organ donation. Yes, listen, if it doesn't cost you anything, if your gift of life can save a kid or a person, that's almost a no-brainer. Okay, let's briefly talk about probate in New Jersey. I mentioned probate. New Jersey probate's the easiest in the country, similar to the way we handle wills. Rather than have people kind of waste their time sitting in the reception area trying to figure stuff out, we email them a short probate questionnaire where they can at least type in what they know, and then we can fill it in down the road. If someone has the original will, some surrogates offices are still closed to the public, so we fill out the surrogate information sheet ahead of time. We will email it or fax it to the surrogate's office with a copy of the will, copy of the death certificate. Then the surrogate, in a way, has deputized some of the attorneys to have the documents signed in their office, so people don't have to come to the surrogate's office. We mail them by first class mail or hand deliver the original death certificate and a check, so that the surrogate, because the surrogate always needs the original, but then once the papers are signed, then they mail out the papers to the people, and the surrogate typically is say, okay, you're good to go. Think of the surrogate as a fancy name for the will clerk. If the will is proper and everything's done right, the clerk admits it. If it's not done right because it's not signed right, then they can't admit it to probate. A new case came in last week. They sent me the will. I goes, you guys got a problem. There's a signature line for two witnesses, and witness number 2 is blank. The surrogate cannot admit that to probate. New Jersey, by the way, there is an inheritance tax. There's no tax that's due if it's going to children, grandchildren, spouse, stepchildren, but we still need to obtain the waiver on the house and other assets. The waiver then has to be filed with the county clerk's office. There has to be a notice of probate that we send to all the people that are inheriting under the will or would have inherited if there was no will, and that notice of probate has to be filed with the surrogate. The properties are sold and liquidated. Well, the executors opens up an estate account, obtains a tax ID, and then at the end of there's no reading of the will like on TV. Once everything is liquidated, then the executor typically prepares an informal accounting, sends it to everyone. Then the attorney prepares something called a release and refunding bond. If all the people sign that they're satisfied, they're about to get this amount of money, then that gets filed with the county surrogate's office, and the people get their money. If all the beneficiaries don't sign the notice of probate, then the release or refunding bond, then we gotta file a superior court complaint to approve the accounting, and that sometimes takes months and months and months and months. So if we don't get in a release and refunding bond from one person, then we typically have a follow-up letter that says, okay, we got the release and refunding bond from everyone except for Uncle Bob, who lives in New York. And unless Uncle Bob signs it, we're going to have to go through this complicated accounting and file a complaint in the Superior Court. And by the way, all that is going to be paid out of your shares, and it's going to delay everyone getting their money by 6 months or a year. So we put in a letter, by the way, Uncle Bob's address is this place, this is his phone number, this is his email. So typically the family tries to lean on Uncle Bob to sign. But the same thing, doing your own electrical work sometimes is dangerous. Trying to do the own probate thing is dangerous because you don't know what to look for. These two ladies came into my office and they goes, we got this letter. I goes, yeah, it says that there's a $90,000 Medicaid lien. And they said, well, but we gave out all the money. Well, did you do the release or refunding bond? No. We didn't know anything about all that stuff. He goes, well, listen, I got bad news for you ladies. Because you didn't follow the law, you're on the hook for this, well, nobody told us. He goes, well, no, that's because you didn't, it's not the surrogate's job to, teach you the law. That's why you sometimes hire attorneys. So that is estate planning and probate 101. We're going to be have the library email some information on another day. I'd like to now introduce to talk at the end of the program my